You need to be quiet when I'm talking.
This video is for entertainment purposes only. All individuals mentioned or depicted are presumed innocent until proven guilty in a court of law. Please do not attempt to contact, harass, or otherwise engage with anyone featured in this content. Any form of interference with ongoing legal proceedings may result in legal consequences. This video may contain copyrighted material that is being used under the Fair Use Act, Title 17 U.S. Code Section 107, for purposes such as commentary, criticism, news reporting, teaching, scholarship, or research.
For a final hearing. In the process of getting this matter ready, I need to be open with the court that I have disclosed to Mr. Odle, Mr. Thomas's attorney, that we have discovered that, and I have video proof evidence and photographic evidence, that Mr. Thomas has been surveilling my client. He has placed a camera at her residence where he does not reside. We have that, we've got that. And then we learned over the holiday that Mr. Thomas has placed a tracking device here. I've advised Mr. Odle, out of an abundance of caution, rather than having his client take the stand and potentially commit perjury or admit to a crime, and I've disclosed that to him. It's my intention. We tried to resolve it. We were unable to resolve it. We were asking for a restraining order so that Mr. Thomas could not surveil, stalk, threaten Mrs. Thomas, anything in the further. That we can't resolve it, so it's my intention to proceed today. I will be turning this device over to the District Attorney General's Office for prosecution, and I will be filing an order of protection for my client. Based on that, I think Mr. Odle is going to request a continuance.
Judge, just based upon that information that I just received, I'm asking the court to continue the final hearing of this matter so that I can properly advise my client.
And Your Honor, in that vein, I do request a restraining order issue restraining Mr. Thomas from having
Committing any
contact.
criminal acts.
Yes,
Basically surveilling and stalking and there are criminal statutes. I say this just for the record. There are criminal statutes that govern everything that's been alleged to have happened. Now, that's the very reason Mr. Odle needs to have an opportunity to talk to his client. Too often, people in divorce cases tend to think, oh, well, I'm married, I can put a wiretap on the phone or I can put a tracer device on it. But when you're going through a divorce, those things don't apply, and the statutes that are set forth in the state of Tennessee make it illegal to take those types of actions. So based upon the fact that there is some criminal liability potentially for Mr. Thomas, and that Mr. Odle, being a good lawyer that he is, needs to be able to investigate how much liability Mr. Thomas could potentially have in this situation and be able to advise him regarding his procedure. Obviously, it's a fine line you walk with, you don't want to threaten criminal prosecution in order to gain an advantage in a civil case, but by the same token, if the defendant, Mr. Thomas, takes the stand and testifies, it's fair game to ask him about those questions, and therefore the liability that he faces is really an issue that Mr. Odle needs an opportunity to talk about. So I will grant a continuance, but I don't necessarily think it has to be a long continuance. We could set it later in the month unless you two have some reason you couldn't.
No, Your Honor, we'd like to get it. Again, it's a serious matter, and as I said, I've typed up, we're, again, walking the thin line, certainly not trying to get a civil gain. Again, I know Mr. Thomas enjoys hunting and does that with his children, and we had thought a restraining order would be the best thing to go, rather than getting an order of protection that would affect.
Order of protection would prohibit him from having a firearm of any kind.
Where the restraining order would not, but they
Well, I'm
don't.
going to issue a restraining order because, in my opinion, it's nothing more than restraining an individual from performing any act that might be considered to be a criminal act. So I'm going to issue a restraining order that just simply restrains him from stalking, from attempting to illegally surveil or to illegally record or tape record any events that might be taking place. In other words, he can certainly record any telephone call he has with her if he were to have that. I
As
don't
he's a
know that-
party,
Pardon?
if he's a party.
If he's a party, but he cannot tape record, he cannot legally tape record a recording between two other people, neither of whom have consented to it. So you want to talk with your client? I know he raised his hand. Do you need to
He was trying to talk to me, Judge.
step aside and talk to him and find out what he wants before we do this? You want to step aside? Well, you just step right over here and whisper it, because we're in the middle of doing something. I want to know what's going on. So. All right. I'll suspend this hearing and let you two have an opportunity to talk. All right. You want to wait for Mr. Odle to have him in the courtroom when you announce the
Yeah, well, it
agreement?
was just sometimes me hobbling up here, I didn't realize being in a wheelchair for a little over a month, how difficult it is to maneuver in this boot, so.
Well, when I had my foot surgery, I was in that boot for a cast actually, and then a boot long enough that I hope I never have to do it again.
Did you find your client? Oh,
Well, let's first address Ms. Roberts tells me that she thinks that you all have an agreement today.
Correct.
Do we need to have your client here in the courtroom to announce that agreement? So would I, because if he violates the oral agreement, then he's going to be facing contempt. So we will wait on your client, so.
Judge, I think maybe we could institute, if there's possibly anything that we can do, is maybe, like restaurants have the little pagers that when your case is ready to try.
I'm thinking of a shot
Do you-
collar.
Well, again, if we could do it, but if we could just get a pager and say, you're ready to, you're now serving. You could just hit a button and we could buzz and we could come
Well,
in
I've
because.
long thought a shot collar for the lawyers who, especially on docket call days, when you're training a dog, you use that shot collar. I don't like to do that, but that is a method used. And since we usually have a hard time finding the lawyers when we need them, it might be the best way to do it, so. How long are you supposed to be in your boot?
Well, I'm in it for 3 more weeks, and go back to see, I was in the cast and then they put me in a boot.
This is
but
over the broken leg. and-
I split my fibia and broke my ankle. And they had to I got pins and plates in my shin to keep it together, and then they had to wire my ankle back together. And, so, no fun. Okay. Your Honor, what we did, I represent Miss Amanda Thomas, and we filed a petition for a divorce in this case, Mr.
Let me
Odelman.
stop you for a second. Who's the young man that came in with you? The child in this case?
They have two adult children.
They're adults, all right? Mm-hmm. You all want him in here to hear your mess,
I
that's
think,
fine.
I think probably yes, Judge. I think he needs a dose of reality.
All right, go ahead.
If we could go on and get them to raise their right hand. Yes, Your Honor, we filed this divorce actually some time ago, and the parties, at the time the divorce was filed, the parties still owned a home. That home has since been sold and the proceeds have been divided and certain debts have been satisfied. During the pendency of this hearing, at the time they filed for the divorce, this young man seated in the courtroom was still a minor. He is now an adult reaching age 18, so there is no, even though the original case had a custody and a parenting plan, that is no longer relevant in this matter because he has aged out and graduated. So, Your Honor, what we're doing is we're asking the court to allow the parties to stipulate grounds for divorce exist. Mrs. Amanda Thomas is going to be awarded a divorce on stipulated grounds, and each party will be restored to all rights and privileges of unmarried people. Each party is going to be awarded all items of personal property now in their possession, with the only exception being that there's a few items of personal property that are going to be awarded to Mr. Thomas. Those are located in my client's garage. We will get a specific date and time for him to arrive at the residence to retrieve those items and to immediately exit and leave the property. He will not enter the home at the time that he comes there. He will simply be there to pick up his items and to immediately leave. At that, he is awarded a Ford F-150, I believe is his vehicle, that is in joint names. We will include the VIN in the order, and that will be his vehicle free and clear of any claims. She will receive her vehicle totally in her name. As a result of that, she has been keeping, pursuant to the mutual restraining order, she has been paying certain insurance coverages for his vehicle, and he's going to reimburse her today the amount of $1,482.19, which is the cost of his coverage from August of 2023 through February of 2025. So that has been prepaid. So after February, of course, the 30 days will lapse at the time. I think it's the 25th of February when that insurance lapses. So he will have to get a separate policy of insurance at that point in time. Any unpaid court costs he will pay. Those have all been prepaid. There should be nothing else left. But there's going to be, the one issue, Your Honor, is going to be that there's going to be a permanent restraining order issued against Mr. Thomas, and he is to have no contact with Mrs. Amanda Thomas in any way. He will not stalk her. He will not post anything, either positive or negatively, on social media or any other place. He will, about Mrs. Thomas, he will have no contact with her employer, her friends, her family. He will not track, stalk, photograph, video, or have any image of her anywhere. He will ensure that that is not made public. He will not disseminate it to any human being electronically, personally, and have no contact with her whatsoever.
Right.
Ms. Thomas, you've heard what I've announced as the agreement today. That's what you want the court to do. You understand that what I've announced is the terms of y'all's divorce, as if we've had a full hearing, witnesses have testified, and the judge has made the ruling. And so the judge, if the judge accepts the terms and conditions that we've announced, it's as if he ruled on it, because he's going to adopt our agreement as his ruling, and it will be the law as it relates to you and to Mr. Thomas. And is that what you want the court to do? And you're going to remain you're going to keep your surname, correct? You have 2 children, is that correct? And y'all been married and had a relationship with
Total. It's going to be in writing, so you'll be able to read the terms of it and comply with it.
Family part, I mean, as long as it is, yeah. It's a no contact between you
and
yeah, no worries there.
And
It
the
says
issue-
family in there, though.
The issue is, and I just want to reiterate it on the record, you will not stalk, post on social media, or make contact with her friends or family concerning anything about her. You can talk to your children anytime you want to, but you're not going to go and again, to use some language that may or may not have occurred, asking whether she has committed adultery, or calling her your slut mother, or anything like that. You're not going to discuss anything about her. Her name is not going to come out of your mouth to anybody. So we don't have an agreement, we're ready to go forward, Judge.
All right,
No,
have a
I
seat.
said, no, that ain't what I said.
I think, or do you agree
Yes,
with that?
yes, yeah.
Let me just say this. I'm going to approve this agreement, but I want to make sure that everybody understands. You have 2 children. They may be adults, but take it from me that, your involvement with them and your contact with them does not end with the fact that they turned 18 years old. And the fact that you are going to have contact with each other in some capacity because your children are growing up. They're going to get, you need to be quiet when I'm talking. Fact of the matter is that from this point forward, the restraining order is going to be applying to negative things or things that might be said about her. Now, if you choose to poison the well with your children about their mother, that's up to you. But I can guarantee you that if you do that, that will come back to bite you on the rear end, because they'll know that what you're doing, and they'll hold it against you rather than against their mother. I hope that's not going to be the case, but you are prohibited from disseminating false statements or disseminating negative statements about her to any of her friends or family, or trying to contact her employer. The language of that restraining order is going to be very specific, and you're going to have to do that. You might have to say, oh, I've got a right of free speech. You can say anything you want to, but there's a limit to what we call the limit to free speech is when it damages someone else. For example, the example used in law school is always yelling fire in a crowded, falsely yelling fire in a crowded theater where people get trampled to death trying to get out of the theater. That's free speech, but it's not free speech when it causes harm to someone else. So understand, this is all being designed to try to quiet things down so that you can enjoy the rest of your life and she can enjoy the rest of her life without having to worry about whether or not there's something going on between the, if you're worried about, she's going to be worried about whether or not you're following her or trying to find things out about her or whatever. So the main thing I would emphasize in this situation is you need to stop thinking about what happened in the past. Whatever the problems were in your marriage, whatever happened in your marriage, the healthiest thing you can do for yourself and for your 2 boys is to say, this is a line of demarcation. That's in the past. What happens in the future is going to be how you live the rest of your life and what kind of relationship you have with your children. And that goes for you too. I know it would be easy for you to say to the boys about how badly you think their father has treated you, some of the allegations that have been made in this. All you're doing by doing that is essentially harming your children, because it does no good. Too often parents try to win favor with their children by trying to make the other parent look bad so that the children will, be closer to them, or they'll have a better relationship. Children are not stupid, especially when they get to be adults. They understand what's happening. They sometimes do that themselves. So my best advice to you is what I advise a lot of people. Put aside whatever has happened in the past. Try to think more about what's best for your children, what's best for you in the future. You're probably going to have a future relationship. You're a young man by my standards, and same with you. Both of you may have future relationships. And if that's the case, you don't want to start that relationship by having the poison from this past relationship carry over into that. Set it aside, put it behind you, count it as a life experience, and move on to a better life. And trust me, you can build a new life without her being involved in it, and have the rest of your life to enjoy without having to have all of these emotional issues that are happening. One of our old judges that Ms. Roberts and I used to practice in front of, Judge Leonard Martin, used to describe going through a divorce as like taking off all your clothes and running naked through a briar patch. It just hurts all over, and it does. And people who have that emotional reaction, who are hurting emotionally and so forth when they go through a divorce, sometimes lash out. They do things that they wouldn't ordinarily do. So let's just put that aside. Now you can move on and do whatever you need to do to try to have a life for yourself and your children in the future. So I will approve this agreement, but understand it is an agreement effective right now, today, this moment. So don't leave here and do something that would violate that agreement. So, all right, anything else?
No, Your Honor.
Ms.
And again,
Roberts is drawing the order.
I'm drafting the order, and again, like I said, it's a scenario of where the dissemination, if there has been any illegally obtained photographs, videos, things like that, those cannot be disseminated and they cannot be used. And again, that's what we're agreeing, based on what Your Honor has said, There have been actions that have been taken that could be prosecuted criminally. We're electing not to do that because of the children and don't want to put that situation through it. And that's the basis of this agreement, that my client's trying to take to minimize that and try, and that's the necessity of getting this restraining order.
If there were any illegally obtained photographs or any photographs that are being, that later are disseminated, that will be dealt with, and by this court, at least harshly as possible. And that means a contempt of court, 10 days in jail, and, for each and every violation. And Ms. Roberts had one of my clients put in jail for 60 days for 6 violations of a court order, even though she had never been in jail a day in her life. So I have reminded myself of that on several occasions. Is there anything else?
No, Your Honor, that's all.
Oh,
I'll draft
thank
the
you.
order and submit it to Mr. Odle for his signature.